Please the Honorable Court, we the Counsel Krishna Pariyar and Vibha Patel appearing on the behalf of the petitioner in the matter between Janseva and versus Union of India. The first counsel appear on the behalf of petitioner would like to take 15 minutes of the court precious time to deal with the first sub-issue, and my co-counsel would like to take 14 minutes of the court's timing in for dealing the subsequent sub-issues and request 1 minute for rebuttals. If your lordship are well versed with the fact, the counsel shall move to the argument advanced.
Yes.
Sure.
Much obliged. The first issue at hand is that the very purpose of the formation of anti-defection law is not fulfilled, making the law constitutionally challenged. The Council humbly submits before the Honorable Court that anti-defection law was enacted to ensure a party member
Counsel,
does
could
not.
you please, before moving on, could you tell me, is this a writ petition filed for violation of fundamental rights or it's a public interest litigation?
So, if we call, sir, we can say that it is a public interest litigation because it is for the benefit of the larger people, because it's violating the fundamental right of the political parties and voters' mandate of the people.
So, you're filing this under what rules of the Supreme Court?
So, special petition leave.
Your file, please clarify, is it a writ petition, special leave petition, or under what rules you're filing if it's a PIL?
Sorry, Your Lordship, I'm not well versed with the this
This
rule.
law.
Yes, sir.
Okay. Then before you move on, Counsel, could you please tell us, has there been a constitutional challenge to this particular provision of law before?
Your Lordship, yes, it is like by 91st Amendment 2003, the split has been removed, so it's already challenged.
It was challenged, right?
Yes,
So, and it was decided by the Honorable Supreme Court?
yes, yes, Your Lordship.
Are you aware of the quorum of the bench of
No,
that judgment? Okay.
no, Your Lordship.
So since that judgment is by a five bench judges of the Supreme Court, how can a two bench judge of the same court even try to relook into the same issue, Counsel?
Your Lordship, if the matter is decided, the bench can be uh, increased as per the case.
So you want us to refer to a larger bench?
To review the anti-defection law.
Please proceed.
Thank you, Your Lordship. The Council humbly submits before the Honorable Court that the anti-defection law was enacted to ensure a party member does not violate the mandate of the party, and in case he does so, he will lose his membership of the House. But the purpose has not been fulfilled because the disqualification on the ground of defection not apply in case of merger, provided if the said merger is with 2/3 of the members of the legislative party who have consented to merge to the another party. And these provisions concerning the disqualification on the ground of defection has regrettably fallen short of the expectation of the esteemed electorate of our nation. The defection in Indian politics has always been the breeding ground of political instability and uncertainty.
Counsel, before you go on, you're seeing that the defection is a problem in the country, is your whole contest. You believe that the law is insufficient, so you'll have constitutionally challenged it. But if you see from the independence till today, the defection incidents have reduced. That means the law is doing very well.
Your Lordship, I would like to refer to the case of Subhash Desai versus Principal Secretary, where the Uddhav Thackeray government was
The judgment is of which court?
The Maharashtra court.
Maharashtra High Court.
Yes, yes, Lordship.
What were the facts over there?
So fact was that the facts of the case was that the Uddhav Thackeray created a was from the Shiv Sena party, and they created a faction of, like they have a majority, but Eknath Shinde created a split or merger between the party and separated from the Uddhav Thackeray government. So they itself made a leader of the party and challenged the Uddhav Thackeray. So this is because of the anti-defection law, and finally the Supreme Court gave all power to the speaker to decide the case, and if it's not satisfied, the Supreme Court will look into it. But the whole power gave to the speaker to decide the matter.
Is it wrong? The law provides for it. Clause 6 provides for the speaker to decide. Clause 6 of Schedule 10.
Your Lordship, yes, the Speaker have the right to review the law, but we will subsequently, my co-counsel will address this issue.
Okay.
The defection, because it's instability, which shift the focus of the government from governance to government, which needs thorough examination and political reform. It is profound regret that the objective of stability remains largely fulfilled. Notably, the law fails to address the intricacies of the coalition government. I would like to refer this case by Subhar Desai versus
Counsel,
Principal.
just for a second.
Yes, Your Lordship.
You're arguing, if I'm not wrong, you're arguing that the law is inefficient and it is being misused. Is
Yes,
that correct? Is
yes,
that a
yes.
ground? Is that a ground for the Supreme Court to declare the law unconstitutional? Misuse of it or it being inefficient, is that a ground?
So, Your Lordship, the purpose for which the anti-defection law is made, but it's not fulfilling the main purpose. So it's violating many rights, and the people within the party cannot raise their dissenting opinions within the party. So,
Correct, I get it. I get it. So why don't you write a representation to the parliament to change the law if it's not efficient enough?
so,
How can we strike it down?
so to amend by amending the anti-defection law, like how split has been removed, there can be further amendments in anti-defection law to ensure stability of the government.
No, when you say the split has been removed, how did it get removed? By way of a constitutional amendment. Correct?
Yes, Your Lordship.
So you go back to the parliament and ask the parliament, file a representation asking the parliament to amend the law again. On what grounds can the Supreme Court strike it down? Is my question.
So, because it's violating the fundamental rights of the people, so that's why I urge the Supreme Court to look into that matter.
But is that a ground enough?
Yes, because it's a
Under
basic
what rule?
structure.
Under what provision? Under what provision?
So, because the fundamental right violates the basic, because it's the basic structure of our constitution, fundamental right. So, it's the crucial matter which
Could you,
should be
could
looked
you
into.
elucidate and explain on basic structure? What is basic structure? Is basic
So,
structure just fundamental rights? Could you
no,
explain?
sir. No, Your Lordship. The basic structure is which can break down the whole constitutional mechanism. So that is the basic structure. If any law which violate the fundamental right or any crucial part given the constitution, so that's the basic structure doctrine. We can.
Have you contended this in your memorial? I don't see it in your memo. The
Yes, Your
argument
Lordship.
that, is it there in your memo?
No, Your Lordship, we have prepared the speech regarding that.
Okay.
By cases we have referred it.
Okay.
Can you plead something and argue something else, counsel? Is that permissible?
Yes, Lordship.
If you have no pleadings, then I don't think we should consider it, right? Without you pleading it in your written submissions and in your memorial, can the court consider your submissions? This court has time again said without pleading, we should not pass orders. So how can we
Yes,
consider
yes,
this?
Your Lordship, but by explaining the case which we have mentioned, we will refer to that structure, basic structure.
Okay, proceed.
Yes, Your Lordship. The Council, on the behalf of the petitioner, want to emphasize the glaring contradiction that occurs between the independent member and nominated member, as nominated member who are not members of the party have an advantage of joining
Counsel,
a party.
stopping you on and adding to my brother's query as to if a law is ineffective, can we make it unconstitutional? So I think you're aware of the Domestic Violence Act and the Section 498A, etc. Correct? So when that law is being misused and there is 90% acquittal in the matters, the Supreme Court did not hold the law unconstitutional, but it gave certain safeguards. So even as of today, the judgment of 1992, the judgment of Justice Ronington Nariman, all these judgments are giving some safeguards as to how the law should not be misused. So it's already done. There is nothing else that we can do. Or do you have any safeguard that you want us to direct?
Yes, Your Lordship, there are certain discrimination in the anti-defection law, like certain loopholes. This merger loophole is a crucial one, due to which there's lots of uh, instability between the
How many
parties.
instances took place by utilizing the merger? How many?
Uh, so Your Lordship, I'm aware of the one incident which took
Only
place.
one.
Yes,
Is
Your
one
Lordship.
is one abuse? Can we say one instance is an abuse of the law?
Your Lordship, but there are if we can compare the foreign jurisdictions where the parties have a right to raise their opinions by seeing the UK, US, they raise their opinions and there is no anti-defection law which can apply to it. So the major problem in this anti-defection law is that the people are not the if the party whip is given, they can't give opinion against that party whip. So that is the main issue.
Your answer is against your own question, is are against your own statement. Because in UK, if you see, if anyone breaches from their party, also they just walk to the other side of the parliament. There is no question of them being punished. Am I? Please correct me if I'm wrong,
Your
counsel.
Lordship, I'm just aware of the some factual knowledge that they have given the more right regarding that, but our parliament is little bit strict on dissenting opinions.
Yes, please proceed.
I would like to represent a glaring contradiction that occurs between the independent members and the nominated members who are not members of the party have an advantage of joining a party within 6 months to avoid defection proceedings. This arbitrary distinction lacks coherence that independent members are indebted to no party and should be afforded the liberty to exercise their affiliation judicially, undermining the very
Which
foundation of our
paragraph of the Schedule 10 are you reading? Which is this paragraph?
Your Lordship, I'm just reading what the speech I'm preparing now.
I
Because
understand.
then,
No, I'm saying that you're saying that independent candidates,
yes,
you're reading this from which part of the law?
uh,
An
so
independent candidate can join any party, you're saying, right? Are you saying that?
Your Lordship, nominative parties have given the right that within 6 months they can join any party, but independent members have not given the right
What is the
to
difference
join.
between a nominated member and an independent member?
Nominative members are not elected members, but independent members who does not represent any parties, but they are called elected members. So nominated members have the right, given the period of 6 months to join any party, but the independent member join any party, the anti-defection law will apply to it. So this is the contradiction. This violates the Article 14 of the independent members.
Where is the definition of a nominated member and independent and an independent member?
Your Lordship, I've done reading, not aware of the in which clause it is given.
Okay.
Anti-defection. Moving on to the last limb of my argument, it is humbly preferred before the Honorable Court that anti-defection law restrict the right to dissent and violate the fundamental right under Article 19, Clause 1, Subclause A. It infringes upon the fundamental right to dissent. It enforces the legislature to align with the party's position, thereby undermining his duty to hold the government accountable. A striking disparity emerges when one examines this provision in contrast with practices with other democracies. Although a legislature may engage in debate and dissent, he is ultimately coerced into voting by the party whip. The petitioner submits that anti-defection law encroaches upon the individual freedom. This freedom of speech, which is nearly absolute, is not a mere privilege but a necessity that people who are responsible for framing the laws of the country must have the freedom to present their argument which violated due to this law. The Council, on the behalf of petitioner, also wants to draw to the attention that anti-defection law provision is not confined to confidence motion or money bills, but extend to all votes in the House, encompassing every bill and every other issue. The MP or MLA is devoid of the autonomy to exercise their judgment on any matter, compelled instead to unquestionably adhere to the party directives. Uh, the 10th schedule, by employing the term any direction, grants excessive authority to the power to the party, stifling dissenting opinions.
Council, so what all clauses or paragraphs of Schedule 10 are you wanting this court to hold unconstitutional? Which all
Uh,
paragraph?
Paragraph 2, Clause 1, And subclause B of the 10th schedule talks about any direction. Like by employing the term any direction, grants excessive authority to the party, stifling dissenting opinions by suppressing the voice of the individual legislator and compromising the true nature of their responsibilities. The Council hereby rests its first submission and pleads the Honorable Court to
Should
review
we
the glaring.
extend time, brother?
Sorry,
Should we extend their time? It's over, right?
I think the council has finished.
Yes, Your Lordship, I'm resting my case.
Do you,
But I think you haven't answered my brother's question. His
Yes, Your
specific
Lordship.
question is, which paragraph of 10th schedule do you want to be declared unconstitutional?
First of all, the merger provision, which is given the anti-defection law, I would like to request the
which
bench
clause is
to
not?
take a
Which clause?
review.
Council, which
Your
clauses
Lordship,
are you referring to?
Your Lordship, I'm not aware in which clause it's given
You're
merger point.
wanting us to declare something unconstitutional, but you don't know which clause it is?
Your Lordship, any direction is given in two clause, subclause, paragraph 2, clause 1 and subclause B, but I'm not aware of the merger clause in which
Are you
clause.
aware which clause speaks about disqualification, decision to be made by the speaker? Which clause is that?
Sorry, Your Lordship, there is a lag on my side.
Okay. No, I was saying, are you aware which clause refers to the power of the speaker to decide disqualification petitions? Council, which clause? There's a lag from her.
Sorry, Your Lordship, the network is lagging.
Yes. So, hope you're not in Chennai.
No, Your Lordship.
Hope you're well and your network and climate is better. Anyway, which clause deals with disqualification by the speaker?
Your Lordship, the speaker point is with my co-counsel, so I would like to
You
shift
plead
my.
ignorance for that.
Yes, Your Lordship.
Okay. Uh, so since speaker one is completed, Rishabh, could we take a short break of a minute so that we'll adjudicate? I'll just add
Sure. Yeah.
scores so that I don't forget.
Sure. Yeah.
Yes. Shall we start for speaker two?
Yeah.
Yes.
Sure.
Speaker two, your name is Krishna Parihar.
Yes, Your Lordship.
Okay.
The council would like to request Your Lordship to approach the virtual dais.
All permissions granted, council.
Much obliged. The council would like to request Your Lordship to stop us in case our video or audio lags.
Hope
The
that
council, on behalf of the petitioner, humbly submits before this Honorable Court of Indigo that the anti-defection law enshrined in the 50. I'm so sorry. The council, on behalf of the petitioner, humbly submits before the Honorable Court of Indigo that the anti-defection law enshrined in the 52nd Amendment Act of 1985 suffers from the inherent loopholes that have allowed for its persistent misuse, rendering it unworkable. This law, designed to fight political instability.
which are these loopholes, council? From the
The-
heart of this case, we are only asking you, what are these loopholes that you're dealing with?
Yes, Your Lordship. The loopholes we want, as my co-counsel have already aforementioned, that the loopholes of merger, which is the 2/3 majority, wherein the party can.
Which clause? Which paragraph?
We are not sure about the clauses.
You want some law to be held unconstitutional, but you do not know which clause. Do you not have the bare text with you?
Um,
Are you telling me you don't have the Constitution of India in front of you right now?
No, Your Lordship. If you permit, I'll just open it and check.
Yeah, please open it and check and tell us.
Thank you so much. Sir, it is discussed in paragraph 6 of anti-defection law in schedule 10.
Okay. So you're referring to your argument is only restricted to clause 6, right? Paragraph 6.
No, so the speaker point is restricted to that.
Okay. What is the problem with clause 6?
Sir, in the clause 6, the speaker has been given so much of power, which the law vests absolute power in the hand of speaker to decide the matter
So
of
judges of
disqualification.
courts also have immense power. Today, my brother and myself have immense power to hold this law unconstitutional or not. How is it wrong?
Yes, Your Lordship. As we have seen in the case of Kyoto Holohan, wherein Justice Verma in this Holohan's case said that the tenure of Speaker is dependent on the continuous support of majority in the House, and therefore he does not satisfy the requirement of such independent adjudicatory authority as you mentioned of a judge or you.
That is why the law itself, if you see any bad text, it says that judicial review has been made invalid. So now there is judicial review for a judgment of the speaker. So if any person is aggrieved by a decision of the speaker, they can file an application, a writ petition before the High Court or Supreme Court. So how is it bad in
So
law?
because in the paragraph 6, the main question arises is, can the speaker maintain absolute impartiality when deciding on the matters, especially when their own political affiliations are at stake? And if we are talking about judicial review, if at every instance these cases are going to judicial review, it's better to just reduce the speaker power or maybe get another adjudicatory authority for that matter, which does not
How,
depend on
how
the
many
political party.
how many petitions judicial review has been filed after the decision of the speaker? How many petitions have been filed?
Sir, the council pleads ignorance.
Oh, continue.
The exemptions related to merger and split provides a majority of 2/3 presented under paragraph 4 of Schedule 10, which gives a leeway to parties without facing disqualification. And that has created a breeding ground of manipulation and abuse. This has been evident in the case of 2017 Goa's assembly election, wherein the BJP used this loophole to gain a majority through merger, leaving the Congress with a mere fraction of its original seat. Such instances demonstrate how the law in its current form fails to prevent defection and ultimately undermines the democratic process.
Counsel, I'll stop you here.
Yes, Your
So
Lordship.
your first speaker, she made an argument that an individual's, say, an elected member, he should have that freedom of speech to uh, differ from a party whip or a party policy. So that is what you say is a loophole in the anti-defection law. Whereas on the other hand, now you're arguing that a merger of a two-third party member is also a problem. So an individual deflecting is also a problem, and a two-third majority deflecting is also a problem. Don't you think there is a contradiction?
Your Lordship, the 2/3 we are talking about is in with reference to voters' mandate. And the other.
So suppose in a party suppose in Goa, you gave the Goa example.
Yes, sir.
Suppose 2/3 of those members from the Congress party were no longer aligned with the policy of the Congress, so they chose to deflect and go to the BJP party. What is wrong with that?
Your Lordship, if we are talking about the people who have elected them, they have elected these people with reference to the party which they were beforehand in. So now if they'll
Okay.
switch the party, it will be wrong on the side of the voters.
Same thing. Suppose an individual from a party, isn't it his obligation to follow the policy of the party, and when the party has issued a whip, isn't it his obligation to follow it?
Yes, Your
Why
Lordship.
is that then you're saying that that should be protected, that individual rights should be protected, and the right of that group should not be protected?
Much obliged, Your Lordship. Yes, it is their right to, it is their obligation to follow it, but there are some instances wherein if we are not aligned with, if an individual who is elected in a party is not aligned with the political party's agenda or their motive, they, in our constitution, in this anti-defection law of Schedule 10, the party member do not have any voice to speak, which is also violative of their freedom of speech, because they don't have any right to speak about their opinions. And when their opinion are voiced, they are just defected from the party. So this is what me and my counsel are trying to elaborate here.
Okay.
Can't there be reasonable restrictions because an MLA or an MP's rights inside the parliament is not a fundamental right? It is only a constitutional right. So constitutional right is completely different from a fundamental right. When the MLA or MP is outside the house, he speaks whatever he wants, unless he speaks and that affects the views of others, then he goes to jail. But if he's speaking inside the house, it's not a fundamental right. So you can have restrictions.
Yes, your lordship, restriction can be placed on them, but in the parliament, they are not able to raise their voice against. If a party whip is there, the party member are not able to raise their voices because they can't vote against it.
They can very well discuss with their fellow party
Yes.
members outside the house, because before bills are tabled, they will definitely have a discussion. Parties will not introduce bills without their fellow colleagues knowing it, right? So
Yes,
there
your
can
lordship.
be a discussion.
Uh,
Can't it start
Is that the sole ground that it violates fundamental right of an individual inside the house?
no, your lordship, it is not the sole ground, but the merger thing which we are trying to elaborate here is one of the ground of that.
But that ground is based on abuse and misuse. That is not a ground for striking down constitutionality of a law.
Your lordship, the judicial review or the striking down which we are talking about here is the process. The main motive of this anti-defection law made is so that the party will not violate, with the party will not defect from the one party to another party. But if the speaker's role is such of that, then that gives the leeway to party to misuse this. Tooth and merger also gives give party members the leeway to misuse this law.
Again, you are into misuse of the law. Why don't you read Article 13 for me for a moment? Article 13 of the Constitution.
the Supreme Court is going to give time just to read the provisions of law as of today?
Yes, I'm so sorry.
Read it loudly for us.
Laws inconsistent with or in deterioration of the fundamental right, all run force in the territory of India immediately before the commencement of this constitution, in so far as they are inconsistent with the provision of this part, shall to the extent of inconsistency be void.
Okay, so all laws which are inconsistent with the provisions of this part would mean part 3, fundamental
Yes.
rights.
Yes, your lordship.
They should be void. Okay. Now, subsection 2(3), they talk about what all laws mean. And now you read 4, subsection 4
Subsection 4.
of that Article 13.
Nothing in this article shall apply to the amendment of this constitution. Under Article
Correct.
68.
So this 10th schedule is a constitutional amendment. So as per Article 13, a constitutional amendment would not be amenable to any challenge at all, except under Article 368. Now, if you want to read Article 368, it only talks about the procedure
Yes.
that is followed by passing the constitutional amendment. So that is why my first question was that on what grounds are you challenging the constitutional validity of this particular amendment because Article 13 provides for unconstitutionality of only laws other than constitutional amendments.
Yes, Your Lordship.
You understood my question? So how do you deal with it?
Can you just repeat your question once again?
So this 10th schedule, it's been introduced by way of a constitutional amendment.
Yes, Your Lordship.
Correct. Now, Article 13 of the Constitution says any law which is in derogation of the fundamental right shall, to the extent of such inconsistency, be void.
Yes, Your
Okay.
Lordship.
Now, this Article 13 does not apply to a constitutional amendment. Okay, as per that subsection 4. Subsection 4 says nothing in this article shall apply to any amendment of this constitution made under Article 368.
Yes, Your Lordship.
Okay. So how can you challenge constitutionality of a constitutional amendment itself?
Yes, Your Lordship. I would like for you to have a judicial review on this topic. Me and my council are not deeming this to be unconstitutional. We want to make some changes, like we have like the change which we were mentioned in the 91st Amendment Act when the split was removed.
But
So
your
maybe
prayer
that's
says you want us to declare it as unconstitutional in your memo. Do you want to amend that prayer now?
But sir, it is talking that about in Article 368 as well, about deeming it unconstitutional.
See, read 368.
The Constitution of India grants constituent power to make formal amendment and empowers Parliament to amend the Constitution by way of addition, variation, or repeal of any provision according to the procedure laid down therein, which is different from the procedure of ordinary legislation.
Correct.
They are talking about repealing a provision.
Right. But then it talks about 368(2), then talks about that amendment you can challenge only if it is in derogation with the procedure mentioned therein. It talks about a procedure, the way, the manner in which a constitutional amendment bill has to be passed. And if that procedure has not been followed, then you can declare it as unconstitutional. But we are not here. You're not arguing that, while passing Schedule 10 or the Constitutional Amendment 52, the procedure was not followed. This is not your argument.
Yes, Your Lordship.
Your argument is basically, it's twofold. Number one, you are saying it's abuse of the law. Number two, your argument is freedom of speech. Okay, abuse is not a ground for declaring a law unconstitutional. Number two, freedom of speech comes under Part 3, and Article 13 then prohibits such challenge when it comes to a constitutional amendment.
Yes, Your Lordship.
So your petition is not maintainable.
So, but sir, they have bypassed the procedure as well. As we have seen in the procedure, the Constitution, there has not mentioned a time frame within which a speaker has to decide if the party is defected or not. The time frame is
Counsel,
also not mentioned in the
what my brother
Constitution.
judge is asking is not on the procedure being the time frame in the in Schedule 10. Only if the procedure in passing the amendment is wrong, only then can there be a challenge. You're going again into the fact of there being an issue with the how is there any issue in passing this amendment is what my brother is asking.
The council pleads ignorance.
You have any other arguments?
Yes, I would like to move on to the last final limb of my argument.
Council,
Which is?
if I may.
Sorry, yeah, please.
Do you have any instances of how constitutional amendments was held unconstitutional by this court? Are there any case laws?
Can you please repeat, Your Lordship?
So suppose my brother judge had given you the procedure when an article can be read unconstitutional, right?
Yes,
That
Your
is
Lordship.
368 is the parameters, the four walls.
Yes,
And saying previously has this court held any provision of the constitution unconstitutional? Is any provision of the constitution held unconstitutional till today? If so, then we can see those parameters and then we might be able to help your case.
Yes, Your Lordship, there are some laws which have deemed unconstitutional.
Not laws again, not laws. Constitution itself. Is there any article of the Constitution or any schedule of the Constitution which was held unconstitutional before?
Any schedule. Sir, Your Lordship, I would like to refer to the right to property, which was deemed unconstitutional by the Supreme Court. The right to property, which was a fundamental right, but it has removed from the fundamental right now.
It is
But
made
that's
up.
done by the
Fundamental right
parliament.
anymore.
That is done by the parliament by way of an amendment.
Sir, the council, I'm not aware of the question which you are asking.
Well, you just said that the right of property was earlier a fundamental right and it is no
Yes,
longer
sir.
there.
Yes,
Correct?
Your Lordship.
But was it declared unconstitutional by the Supreme Court or was it amended by way of an amendment by the parliament?
Sir, the council pleads ignorance here. Because I don't have knowledge whether it is done by the parliament or by the Supreme Court.
Okay. Any other argument?
Is you have any other argument, the council?
No, Your Lordship, I would like to move on to the prayer.
Before the prayer, council, have you read the judgment in Quixote Holohan versus Zalichu and others, the 1990?
Yes, Your Lordship.
You have read the judgment. Then you will be having answers to this question by my learned, by both of us. What was done in that judgment?
Split has been removed in that.
No, council. Split was not removed by a judgment. Split was removed by a constitutional amendment.
Quixote is that 1992 judgment.
Yes, Your Lordship.
And what you're talking about, removal of split was by way of an amendment in 2003.
So we are not aware of that.
At least when you're not aware, do not guess it.
Yes, yes, Your Lordship.
Yes, you can move on to your prayer.
Wherein 4, in the lights of the facts stated, issue raised, argument advanced, and authority cited, the petitioner humbly prays before this honorable court to be graciously pleased to firstly hold and declare that 52nd Amendment Act of 1985 containing anti-defection law under the 10th schedule constitutionally invalid.
Council, you want us to declare. So what kind of a writ are you asking? A writ of mandamus, quo warranto, prohibition?
Prohibition. And from the second prayer, we want the writ of mandamus. We are seeking for the writ of mandamus. Secondly, we urge this honorable court to take decisive action in ensuring that the anti-defection law serves its intended purpose and upholds the principle of fairness and justice in an electoral process. Much obliged. It was indeed an honor to argue before this honorable.
Thank you. Rishabh, I'll just take a minute.
Yeah, sure.
Rishabh, shall we start
Yeah.
respondent side?
Sure.
Yes, respondents. Council 1.
The council seeks permission to present the case, Your Lordship.
All permissions granted. Just argue the case.
Your Lordship, the council would like to brief what are the issues that the council would like to argue. The first issue is whether the writ petition is maintainable. The second issue is whether the office of the speaker satisfies as the independent adjudicatory machinery. The third issue being whether the inclusion of 10th schedule to the constitution is violative of the basic structure of the constitution. Fourth is that whether the 10th schedule violates the rule of law under Article 14, 19, and 21 of the constitution. The council number 1 will argue with first and second issue, and the second council will argue with the third and fourth issue. If the lordships are okay with the fact issues, the council seeks permission to argue for the first issue. Lordship. The first issue being whether the writ petition is maintainable. It is humbly put forth by the council on behalf of respondent that this writ petition is not maintainable as there is no substantial question of law nor any infringement of fundamental right. It is
Council,
important to know.
Council, please understand that a PIL is filed not for substantial questions of law. Substantial questions of law are framed in a second appeal. Are we in a second appeal? No. So PIL can be filed asking anything.
Indeed, your lordship.
Tomorrow,
The council.
if some remedies have to be provided, they can file a PIL. You cannot ask, there is no substantial question of law that is required in a PIL. Where have you read this from?
Indeed, your lordship, the council would like to state that there is no infringement of fundamental rights, hence this writ petition should not be maintainable in the first place. The jurisdiction of Supreme Court can only be invoked under Article 32 only when there is an infringement of fundamental rights. Here, the 10th schedule was inserted to discourage the defection and also to curb the evil practice of defection. Defection endangers the foundation of democracy, and with this inclusion, there is no violation of fundamental rights, Your Lordship. Also, in Quixote Ulan's case, it has been clearly stated that 10th schedule is constitutionally valid.
Council,
Thus,
you're very clear of Quixote's judgment, right? So in that judgment,
yes,
the writ was maintainable. So why we should consider this writ as not maintainable?
yes, Your Lordship, by stating a maxim that is interest republicae ut sit finus litium, which states that in the interest of state there must be an end to litigation. Also, the council would like to quote the principle of res judicata, that is where the issues has already been declared by the court and already been discussed elaborately. This honorable Supreme Court is not under a mandate to take this writ petition, Your Lordship. And also, this
Council,
writ petition is no longer.
Council, this is a change of so many years. 1992, the decision was passed by this court. Today we are in 2023. Why
Yes, Your
can't we
Lordship.
consider how does principle of res judicata apply, and will principle of res judicata apply to PILs and writs, or does it just apply to CPC? Are we bound by CPC?
The council would like to quote that there is instances that res judicata can be applicable because this whole 10th schedule has been elaborately discussed in the Quixote Ulan's case.
No, no.
And
You tell me
simply
how
because
the principle of res judicata can be applicable in a writ jurisdiction. Has the Supreme Court ever said in writ jurisdiction that principle of res judicata would apply?
Indeed, Your Lordship, but this court can look into the instant that this has been already discussed.
So first time. So never it happened before.
Indeed, Your Lordship, the council would like to put forth that they can consider this as a suggestion from the council, from the respondent side, Your Lordship.
We also give only suggestions to the parliament now. Huh? I don't think this is
Yes, Your Lordship.
I don't think this is how the PILs are to be looked into. Maintainability is not to be looked into at this moment because we would like to see, because the law is very unfair, is what my brother judge and myself feel. That is why we're listening this matter. So the writ is the PIL is maintainable.
Yes, Your Lordship. Now the council, if the maintainability issue is the presented by the council is presented, if the council is satisfied with the maintainability issue, the council now would like to continue with the second issue.
Yes.
Much obliged, Lordship. The second issue being whether the office of the speaker satisfies as the independent adjudicatory machinery. It is humbly put forth by the council on behalf of respondent that the chairman or the speaker, while deciding the defection cases, is held to be a person who enjoys a very high status and position with regard to great respect. And also in the parliamentary traditions, he is said to hold a very high respect. And also, he is a very embodiment of property and
Council,
impartiality that has been.
all these are uh, empty statements, I would like to say, because
Yes,
if you see instances of the speaker, they keep the petitions pending till the dissolution of the house itself, and then people have to come to the Supreme Court. So instead of everyone, we already have so many matters pending. Why do you want to increase our burden? We will add a independent authority with retired Supreme Court judges and High Court judges. Let them decide this issue. Speaker is not doing a judicial job because he is not a judicial person. He's not from the legal background. How will he pass a judgment?
ignorance, Lordship. The council would humbly state that what has been stated in the Quixote Ulan's case, because these are the statement that was given by the Quixote Ulan's judgment that the office of High Speaker is one of the reasons for holding the 10th schedule as that constitutionally valid, Your Lordship.
What was the which part of the judgment are you reading?
The council would like to humbly share the screen so that the
Okay.
council would like to show the compendium.
Okay.
Your Lordship.
Technology is to reduce time wastage, not increase.
In the Your Lordship. Yes, Your Lordship. In the case of Quixote Ulan versus Zachilu, it has been stated that
I can't see anything. It's a black screen.
this,
Yes, you can. Okay.
yes, Your Lordship, the speaker or chairman, while functioning under the 10th schedule, is to hold a person as a tribunal in this case, Your Lordship. And also, the council would
Once
like to
again,
state
you're yourself telling that it should be a tribunal.
the statement that is given in the judgment is what I would like to put forth, Your Lordship.
Exercises the powers and acts as a tribunal. Okay. But
Yes, Your Lordship. And
have
then
you seen the decisions of the speakers of the various houses and compare it with any judicial decision? Can you see there is a glaring, stark difference? It's not a judicial order at all.
this is the judgment that is we have taken, Your Lordship, and this is what we would like to highlight, Your Lordship. That he is said to be an independent person.
You just tell me, counsel, you belong to one political party and you are going to decide a decision against the opposition party. You think you're going to be fair?
Lordship, can you please repeat your question, Lordship?
If you're from a political party and the opposition comes with a petition against, so you think you're going to be fair? You're going to go
Uh,
definitely pass a judgment otherwise.
no, Your Lordship, it is very important to know that he is a person who is above all political consideration. That is why both the parties, that is the opposite party and also the ruling party, elect him as a person to decide all these defection cases, including, Your Lordship. All the well-being of the houses and members of the elected members are decided by the speaker, Your Lordship.
Council, you
Yes, Your
understand
Lordship.
of bias, right? There are two types of bias. There's an actual bias and there is an apparent bias. Okay.
Yes, Your Lordship.
Isn't this a case of apparent bias?
The council states that it is not. There is no bias on the ground of speaker lordship.
No, by him being
Just
affiliated to a party and being nominated by a party, isn't it a case of apparent bias? Why is he going to rule in favor of me?
because he is being a party member doesn't make his decision that the political there will be no political influence is my point, your lordship.
So
Just he
council,
is
so council, you're
already
telling me,
member of
so council, you're telling me if Krishna Parihar is my nephew, is my niece, you're okay with think there will not be bias? Or as my learned brother judge also pointed out, do you think
this is the case where
shouldn't shouldn't I
there are
recuse?
be
If Krishna Parihar is my niece,
what you
shouldn't I recuse from the matter? Yes or no? Should I or should I not? So I know you know the answer. So in that regard, don't you think there is apparent bias for the speaker to decide?
there can be amendments, Your Lordship. Once, when the Speaker has been elected, he can be given an opportunity that he can leave from his political party. Because if such amendments are created, I think the Speaker will hold a better position, Your Lordship. So, the argument from the respondent side is that the should not be held unconstitutional because he is a person who is within the house and he knows all the matters that is going within the house. So whatever that is going within the house should be within the house itself, Your Lordship. That is what the point that the council would like to put forth before this honorable court.
Why outside the house they cannot decide? Huh? The judicial
Uh,
bodies cannot decide.
this is a case where defection is dealt, Your Lordship. So, if defection is dealt within the house, it would create more stability and accountability to the people, Your Lordship. And also, the council would like to state that there is judicial review with regard to decisions that is rendered by the speaker, Your Lordship. So, if there is any misuse of that power, obviously, a person who is aggrieved party can go to the Supreme Court and they can proceed with their rights, Your Lordship. So, making this paragraph 6 as unconstitutional will not fetch any, will not help the stability of the government, Your Lordship. If the lordships are satisfied, the council would like to proceed with the second sub-issue, Your Lordship. So, Lordship, whether paragraph 6 is violative of Article 21 of the Constitution, it is humbly submitted that the Speaker or a chairman hold a very pivotal position in the scheme of parliamentary democracy, and he is said to be a person who is a guardian of the rights and privileges of the House. And also, it is important to note that the independent adjective machinery that is given to the speaker does not vitiate the likelihood of political bias. This political bias is said to be unsound and it should be rejected, Your Lordship, in the first place. And secondly, the council would like to argue that the power that is given to speaker is in public authority that should be viewed as trust that is coupled with a duty, Your Lordship. And also, he is said to do his work in the interest of large public and social interest. Thus, putting forth all these contentions, the council would
All
like to
these are
state that
all these are empty statements to just support the point that the speaker has no bias. But there seems to be reasoning lacking in these points. These are just like our fake promises made by the members of the houses actually before being elected. They're a bundle of promises. Here also you're just making just a usage of rhetorical or flowery language, if I may put it. He's a good person, he's a person in authority, he has to do this. No, how do we expect him to do that when he's elected from one particular party?
yes, Your Lordship, and this is one of the ground, and also many parliamentarians also stated that he is a person who is said to be impartial. So, based on this ground only, I think the council thinks that the constitutional validity of paragraph 6 is also held a constitutional in the Quixote Lance judgment, Your Lordship. Also, the council would like to quote paragraph 6 of the 10th schedule. That is, with regard to paragraph 6, the speaker can create any rules with regard to anti-defection law. Thus, this paragraph 8 also complies with the principle of natural justice. Hence, the procedure that is established by law is being fair, just, reasonable, and it is not oppressive, Your Lordship. Thus, paragraph 6 does not violate the Article 21 of the
The
Constitution.
council recently, I think, uh, Mawa Motra was expelled from the parliament, right? Are you aware of it?
Uh,
What was the
sorry,
procedure
Your
for?
Lordship.
What was the procedure followed? Though it was not a question of defection, it was a question of expelling a member. There was a parliamentary committee, the committee sat. So in such a manner, even defections can have a committee sitting with judicial and members of the house as well. Say two members from the house, say the speaker, two judicial members, they can form a committee and the committee can sit and decide. But wouldn't that be a better alternative?
Yes, Your Lordship, in order to provide justice to the aggrieved party, certain amendments can be made, Your Lordship. Speaker is a person that he has independent adjudicate. He can also be included, and along with the opinion of election commission or president can also be considered, Your Lordship.
So you're conceding that we can pass an order to that effect. You concede.
Yes, Your Lordship. Amendments can be done in order to provide justice to the people,
No,
Your
no, no.
Lordship.
Amendments or we can give directions. You're conceding if we are giving such a direction. You're okay if we pass a judgment like that.
Give suggestions, and we can ask the parliament to create amendments, Your Lordship.
But you agree that there are problems with the law. There are problems with the 10th schedule.
There were no problems as to 10 schedule, Your Lordship. There were some of the misuse that is done by the political parties, and certain amendments can be done in order to make that law more effective, Your Lordship. It should not be held unconstitutional. The main purpose of this writ petition is to make unconstitutional, Lordship. The council humbly puts that this should not be held unconstitutional, Your Lordship.
Partly unconstitutional is fine.
Lordship,
Partly
I think
unconstitutional is fine.
the amendments can be done so that it could be still more effective, Your Lordship. The council rests the case and like to invite the second council to brief the third and fourth issue, Your Lordship.
Rishabh, I'll just take a minute. Shall we start, Rishabh? Okay.
Good afternoon, Your Lordships. This is the second counsel appearing on behalf of the respondent in the case of Janaseva versus Union of India. The counsel will be dealing with the third and fourth issue, and also the second, also the two sub-issues under the fourth issue. The counsel seeks permission to continue with the third issue of the case. Much obliged.
Yes, yes, granted.
Third issue, whether the inclusion of the 10th schedule is violative of the basic structure doctrine of the Constitution. The Council would like to state three major features of the anti-defection law in the 10th schedule before furthering into the arguments. First one is
Before that,
purpose.
council just explain to us what is the basic structure doctrine? What does it encompass?
Basic structure doctrine gives certain ideas to the pardon me, Your Lordship.
Everyone knows it has come in the decision of Keshav and the Bharati. Everybody knows
Yes, Your
there is
Lordship.
basic structure. But what is basic structure actually?
Basic structure doctrine includes certain basic structure doctrine includes certain principles which are like parliamentary democracy, judicial review, judicial independence, majority for the majority representation, and many more. It also includes the fundamental rights and the
The basic structure doctrine was there, it came with the judgment. So the judgment would have given a specific explanation of what is the meaning of basic structure. And instances, and Keshananda Bharati itself runs into so many pages. In that entire judgment, there is no explanation of what is basic structure. Structure.
The judgment states a certain qualities of the Constitution as basic structure doctrine, which is the supremacy of the Constitution, union and sovereignty of India, sovereignty of the Constitution, it's a democratic and republic form of the government, federal character of the Constitution, secular character, and separation of power and individual freedom. And several others are also considered to be the basic structure doctrine.
So suppose principles of equity, fairness, good conscience. These are not parts. Suppose the part of the constitution breaches the principles of equity, fairness, and good
Once again,
conscience.
your lordship, you are not audible. Please continue, your lordship. Sorry for interrupting.
அந்த பொண்ணோடது நீ கேட்டு வாங்கினேன் நீங்க எல்லாம் ஞாபகம் இருக்கு உன்னோடதுன்னு சொல்லிட்டு உன்னோடதா பார்த்து எடுத்துக்கணும்னு நீ எடுத்துட்டு
Sorry, your lordship. Sorry for the interruption.
Looks like, yeah.
I lost my question. The issues of equity, fairness, and good conscience, principles of natural justice, are they also a part of basic structure or not?
Yes, your lordship. They are
They
the
are.
part of it.
Okay. Please proceed.
Yes, your lordship. The genesis of the legislative provision lies in the recognition that political defections represent a significant threat to the fundamental principles of parliamentary democracy. The statement of objectives and reasons accompanying the introduction to the anti-defection law of the Constitution explicitly identifies the evil of political defections as a matter of national concern, necessitating decisive measures to curb this menace. The crux of rationale, according to the National Commission to Review the Working of the Constitution, 2002, is grounded in the idea that electoral victories of the candidate is also based on the party that endorses them.
Council, you're
And
relying on law
defection in this,
commission reports. Are you
yes,
are you relying on law commission reports?
yes, Your Lordship.
And there were law commission reports which also said to remove this particular clause of merger. Then there were law commission reports which also spoke about judicial review, independent body. So then you can't use one report and skip the other report, no?
Your Lordship, I will be proceeding with the. I will be using that in the furtherance of the arguments, Your Lordship. um, in essence, and contravenes the very mandate upon which the member was elected. In this, Dinesh Goswami committee recommended certain restrictions to the disqualification, suggesting that it should be limited to certain instances. If your lordship may permit, the council would like to share the respondent's compendium for the reference.
Yes.
Thank you, lordship.
Please increase the Zoom council. We'll need two spectacles. What are you relying on? Is this a judgment or what is this actually?
This is the Dinesh Goswami committee report.
Committee report, okay. Are we bound by committee reports? If we,
No, your lordship, we are just giving suggestions which are given in the Dinesh Goswami committee.
Okay. You're for the 10th schedule, right? You being the government, you're not against it.
No, your lordship, we are for the 10th schedule.
So, which part of this is supporting you?
This is supporting the paragraph 2, subclause 1, subpara 1, clause B. It is given in a, it is highlighted here that disqualification provisions should be made specifically limited to the cases A, voluntarily giving up of an elected member or membership of his political party to which member belongs, voting or abstention from voting by a member contrary to the party direction or whip only in respect of motion of vote of confidence or a motion amounting to no
Council,
confidence
you
or money
yourself are telling that this 10th schedule now should restrict itself by virtue of this. So, you believe that it should not be unrestricted like it exists. You yourself are suggesting a change. Am I correct?
I think even I understand the same. You are arguing that the law should be changed.
No, Your Lordship, I am suggesting that these these were given by the Dinesh Goswami committee, and this should be adhered to.
You believe that there should be a restriction?
You read the opening.
Yeah.
The committee has accordingly recommended that the anti-defection law should be changed in the following respects.
Yes, Your Lordship, here I am stating that the 10th schedule should not be completely removed, even though we can have amendments or corrections in the law, but it should not be completely removed as it is a necessary evil.
That is what the petitioners are arguing. They want change.
Declare it unconstitutional and let the parliament come up with the amendment to make it workable. Because you agree today that it's not workable, it needs amendments. So let us declare it unconstitutional and the parliament can make amendments.
No, Your Lordship, it is a suggestion that the court can suggest the parliament to amend these laws, to
Court
amend
will
and
not give
include
suggestions.
suggestions.
Law commission reports will give suggestions. The court will pass directions, and we can give a direction to hold it unconstitutional, like my learned brother
No,
is.
Your Lordship. No, Your Lordship, 10th schedule cannot be held unconstitutional as it is a necessary
Council, you
evil.
just see your opening line. It says 10th schedule should be changed, and the recommendations are listed there. And you just see point number 2, though you highlighted point 1. Point 2, power of deciding should be disqualification should not be left to the speaker. This report is completely against you and for the petitioner. How is
The
this
petitioners were arguing. The
It is
petitioners were
supporting
arguing
the
to
petitioner.
as the issues are different for each of the teams. Here, the respondents believe that the petitioners were arguing for the complete removal of the 10th schedule. The
They're
respondents are
okay with even
recommend.
they were saying about this only. What they were arguing only you're conceding. They were okay with minor modification. You can stop sharing the screen. My learned brother, I think the petitioner argued only minor modification.
In the end, they argued that a partial modification would also
Sufficient.
suffice. Yeah.
And you're also okay with partial modification, council too? And we'll just allow
No, Your Lordship.
modification partly.
No, Your Lordship.
No?
Either you can argue that, although you agree that the law is being misused, but it is not unconstitutional. Is that your argument?
Partly, Your Lordship. Yes, the law as of now is also is good, but to make it better, we can have slight changes. Is what it is being argued by the respondents.
And why is it not unconstitutional?
Because these the provisions in the 10th schedule is actually helpful. The split was removed from the 10th schedule, which was actually arbitrary, and but it held mergers to be constitutional. Mergers provides 2/3 of the political party members can actually remove themselves from the party if there is anything that is happening which the 2/3 members are not supporting.
In which case was this held to be constitutional?
Pardon, Your Lordship.
People said split was removed, but the merger was held to be constitutional.
In the 91st Amendment, Your Lordship.
In the 91st Amendment, the 2003 Amendment, is it?
Yes, Your Lordship.
That's an amendment. There is no one held any provision to be constitutional or unconstitutional. It was an amendment by the Parliament.
But the split.
Huh.
But the split was held unconstitutional. At the same time, if merger was unconstitutional,
was held
the 91st Amendment could also.
Where
split
are you
was
getting this
removed,
from?
omitted.
Was the split held unconstitutional?
Split was omitted from the 10th schedule.
Correct. It was omitted by an amendment by the Parliament.
Yes, Your Lordship.
Because the Parliament thought it might not be workable or helpful or not helpful for whatever reason. Correct?
Yes, Your Lordship. But at the same time, if merger was also not working, they would have removed merger too. But merger was working as foreign political parties. Thereby, they did not remove it because it was held on.
Council, very simple
It is
question.
constitutional.
Which judgment are you relying on to say it was constitutional? To say it was omitted, it was not unconstitutional. Which judgment are you relying on to say the law was constitutional?
I am pretty sure in Quixote Hologan's case, they held the merger as constitutional. The rest of the provisions of the 10th schedule as constitutional.
So we're going to work on guesswork today.
Moreover, the third feature of the anti-defection law is about the appointment of the speakers. It is justified on the grounds of the internalizing political party matters within the parliamentary boundaries. Acknowledging the importance of maintaining the democratic rights of the members, judicial review of the speaker was brought in. Moreover, in Kesham Singh was the speaker, a 3-month period for the speaker to make a final
Which
decision
High
is
Court or
taken.
which Supreme Court judgment?
Kesham Singh, Kesham Singh was the speaker in 2020. It was the jurisdiction. I plead ignorance for the jurisdiction of the case.
You don't know which court passed the judgment?
It's Supreme Court, Your Lordship.
Supreme Court. And what were the facts there?
The facts was about the speaker taking too much time to decide upon the cases presented before him.
So that
And,
again is the judgment is
no,
against
Your
you.
Lordship, the judgment said that the speaker should be given a 3-month period to decide upon the cases presented before him. So there is judicial review in it, and there is a limitation to whatever the speaker is given, the limitation to the authority of the speaker.
Okay.
Any other issue that you have or dealing with?
Issue, Your Lordship?
Any other argument that you have?
Uh, yes, Your Lordship. The argument centers around the exemptions for political party mergers. The Bombay High Court's interpretation of the 10th schedule eliminates two distinct possibilities concerning party mergers. The distinction underscores the importance of legislators' agency in either supporting or opposing a merger. The recommendations of a repeal of provisions exempting certain mergers from the 10th schedule. The rationale behind this recommendation is rested on the principle that a person elected on the ticket of the political party should remain with it throughout the term, and any desire to leave the party should entail leaving the legislative house as well. The provision for merger is essential as it provides elected representatives with legitimate recourse when a mass disagreement with their party's decision. It aligns with the democratic principles of considering the political opinion within the party, ensuring that the substantial portion supports any decision, including the merger. Hence, it is humbly submitted that the 10th schedule is not violative of the basic structure doctrine of the Constitution, but merely a regulatory mechanism for defections in India. If your lordships has no queries, the council would like to continue with the fourth issue.
Should we extend the time, Rishabh?
Just quickly summarize what your fourth argument is.
Yes, your lordship. The fourth issue, whether the 10th schedule violates the rule of law under Article 14, 19, and 21. It is humbly submitted that the 10th schedule lays down provision for the disqualification and defection of members of parliaments and state legislature. Anti-defection law, while viewed as a necessary evil, are essential to prevent continuous defections that could challenge the stability of the government. The right of freedom of speech of the elected representatives are not violated, given the provisions in the paragraph 2, subpara 1, clause B of the 10th schedule. This clause states that a member who votes or abstains contrary to the party's decision can seek prior permission, or the party may condone the act within 15 days. Therefore, it is contended that when a remedy is available, it cannot be considered a violation of rights, but rather than a regulatory mechanism. The mergers are highlighted as an exception because when two-third majority of the political party opts not to continue with the party, it is seen as an exercise of majority
Council,
views.
it is
This is also
two-thirds. It is two-thirds of a legislature party or political party. The
two-thirds of the political party.
political party. Okay.
Yes, Your Lordship. This is also viewed as an exercise of the collective privilege of members of the parliament and state legislature under Article 105 and 194 respectively. Additionally, it is also contended that the right to personal liberty under Article 21 is not violated, as members possess both individual and collective rights to make the decision in Parliament. Hence, the Council humbly submits that 10th schedule does not violate rule of law under Article 14, 19, and 21. The Council would like to move on to the sub-issue 4.1.
Shall we ask him to move on to the prayer?
Yeah.
Please move on to your prayer, Council.
Much obliged, Your Worship. Therefore, in lights of facts stated, issues raised, arguments advanced, and authority cited, it is humbly prayed that this Honorable Court be pleased to hold, adjudge, and declare that the petition to be dismissed. The office of the Speaker satisfies as an independent adjudicatory mechanism. The inclusion of the 10th schedule in the Constitution is not violative of the basic structure of the Constitution. The 10th schedule does not violate rule of law under Article 14, 19, and 21 of the Constitution. Hence, it should be held constitutionally valid. The Honorable Court may pass any other order or decree as it deems fit in the interest of justice, equity, and good
Council, when you're
conscience.
already asking first to dismiss the writ petition, all these things, can you pray? Once you are already asking for a dismissal of the petition, can you as respondent seek declarations? The writ, once you dismiss it.
I apologize, Your Lordship, I cannot. And for this act,
You
kindly
agree that it should
understand
pass
that
directions that the law is not workable and it should be amended. That you agree with.
I do not necessarily agree with it, Your Lordship, because the current laws are actually working properly and they do not need any further amendments. But if there is any discrepancies that arises, then the law can be amended.
Uh, we have to give time for rebuttals because we are given sufficient extension of
Any
time.
rebuttal?
Shall we give rebuttal time? 30 seconds?
Sure, yeah.
Okay. Yes, petitioner rebuttal.
The council seeks permission to approach the dais for rebuttals.
Rishabh, are we giving 1 minute or 30 seconds for
30
rebuttal?
seconds is fine, I think.
Yes, okay. 30 seconds for each team. Right.
Yeah.
Your Lordship, as mentioned by my learned opponent counsel, about the case of Kesham Singh versus Honorable Speaker Manipur Legislative Assembly. In this case, the court recommended the Parliament to amend the constitution regarding the role of Speaker as a quasi-judicial authority while deciding the disqualification petitions. Also, in this case, the court suggested that an independent tribunal can be appointed which will substitute the Speaker of the Lok Sabha and Legislative Assembly to deal with the matter of disqualification under 10th schedule. Further, I would also like to pinpoint the argument presented by my learned opponent counsel upon the maintainability of the PIL. As we consider this writ petition as the PIL, I would like to present the case of, the council would like to present the case of SP Gupta, wherein it was held that any member of the public acting honestly and with a significant desire could file a lawsuit to correct a public wrong and injury. Therefore, this petition, which is the PIL by the NGO Jan Seva, is done by a publicly active and honest NGO, which should be maintainable. And the court recommended in the case of Kesham Singh that should be also considered.
Okay. Respondents, do you have anything?
Yes, Your Lordship. The petitioner contended that 2 by 3 of the political party merging with another political party is unconstitutional. But however, in Article 105 and 194 gives two privileges to the elected representatives. Here, the individual rights, one is the collective representation as a party and individual representation. Here, individual rights as an individual elected member and collective rights of the 3 by 4 majority is being infringed. Hence, it is not violated, Your Lordship. Also, the petitioner argued that they are arguing for the amendment, not for the constitutional validity. However, the proposition asked uh, the constitutional validity to be contended. That's all, Your Worship.
Okay. We hold the rounds as complete.
Yeah.
Rishabh, should we give, will you give the feedback first or we'll discuss
We-
the scores before we give
Yeah,
feedback?
let's discuss the scores and then we can give feedback.
Okay, could you, Court Master, put the speakers in the waiting room?
Yes, Your Lordship.
You all can just leave the room, speakers. You all can yourselves leave the room. Yes. Uh, Hello, Rishabh. I take a
Hi.
lot of your time on.
No, no. I had fun doing this.
Okay. Uh, so
So,
you
so
like the rounds?
yeah, yeah. But very neck to neck, I think for both of them, that knowledge of law is a big problem.
Yes. I felt like I was not happy with both. I felt both the speakers from the petitioner were average.
Correct.
But from the respondent, I like speaker one a lot. She was very
Yeah.
good.
So the oratory was good, but then again, the contentions that they've taken, they've kind of conceded everything.
Conceded everything. Yes.
Yeah.
Conceding they should not do. That is true.
Yeah.
They spoke well, but they
Correct.
conceded.
Correct.
Respondent two, speaker two didn't know anything.
Correct.
She didn't know
Yeah.
basic structure. She didn't know legislature party. She gave that commission report which was against her.
Correct. Correct.
So that way, if you see,
So as
uh,
a team, it becomes problem. It's very tight then.
yeah. So I felt like if I would share my screen, could have a look at. Mm, so what I did was I gave average marks for court manners anyway was good for all four. They
Correct.
patiently heard and listened to our queries.
Mhm.
So I gave for both council one.
Mhm.
Mm, I think this is the score sheet here. Given the name also. Yes. Speaker one is what's her name?
Vibha Patel. Vibha Patel. Yeah.
Patel. One second. Vibha. Yeah, so I have given average marks to Vibha.
Right.
Given to speaker two, except
Speak.
court manners, I have given them average and good ke beech mein.
Mhm.
Coming to respondent, I like though she conceded, till the time she conceded her knowledge of law was good.
Yeah.
She made a big blunder on this knowledge of
Correct.
conceding.
Correct.
So till such time, I was very happy with her actually.
Yeah.
So I had given excellent for law and citations. I reduced the mark there.
Mhm.
What I did. But for
Mhm.
speaker two, I gave again very less
Okay.
score. This is what I
So
was.
this is also, this is the way I'm also going to mark. So
Okay.
collectively, then respondents are going to go through.
Okay.
Yeah.
Oh, so I'll have to just see if that total is done.
I think that the speaker won for the respondent, I think, because of her.
I think they will go through. Yeah, because yes. I think speaker respondents only will go through in mine.
Yeah.
Correct. Yeah. So
All right.
you're also on the same page.
Ah, go less.
ठीक
Should we bring them in? What should we do?
Akshay, could you bring back the students to the room?
They have left
Where you
completely.
call them and tell them to join.
Yes.
Y-
Oh, that's fine then. They don't want feedback. It's okay.
No, actually, what happened is I think my person, instead of making them go to the breakout
But
room,
they left. Huh?
they left the meeting only by mistake, I think.
So that's fine.
Bichare, they might be waiting for this. Where are you practicing, Rishabh?
Raipur.
Raipur. Okay.
Yeah.
Raipur. I need people from our ILS over there.
There's super seniors. Like there's one from 2004 batch called Ali Asgar.
Oh,
Then
very
there's 2006 batch with Sharma, but not many.
not many. Okay.
It's basically all HNLU people who, after they are the ones who join the court. Otherwise, बाहर के तो कोई नहीं है.
Okay. Okay. Okay, we have the team. Okay. So Krishna Parihar, your other teammate is there with you? Krishna, your voice is
Yes, sir. She'll be joining in a second.
no. Okay. Rishabh, why don't you please start with your feedback?
I'll start with Krishna, of course. See, you can't be, Googling everything when we ask you a question. You're arguing challenging constitutional validity of a provision, but you don't have the book in front of you. It's one major problem, because if I'm asking you to read a provision, you will have to open Google and take out that provision.
Yes, sir.
Then the basics, of course, when you are challenging constitutionality, you have to know under what grounds. That the first question that you have to see is under what grounds can you challenge constitutionality, whether the act permits it or not. So knowing, Article 13 and 368 is the most important thing. You guys kept on arguing on, misuse of the law or abuse of the law. That is not a ground for challenging constitutionality. That may be a ground for the parliament to, consider and amend the law. And again, I believe there was some problem with knowing what a constitutional amendment is or what declaring a law unconstitutional by the Supreme Court is. These are completely two different things. Okay,
Yes.
so the parliament can amend a law by way of a constitutional amendment, but the Supreme Court will have completely different grounds to judge whether a law is constitutional or not. And that would be only under Article 13 or, on the grounds that this is against the basic structure of the Constitution. But in your memo, the word basic structure is missing.
Yes, sir.
That was the only point you had to argue. Okay, so that you will have to do a lot more reading on, the Constitution. Otherwise, the oratory was good, the speaking, the court manners and all of that was good. The memo has a number of judgments that I've seen, so the research was also good. But a little understanding of how the Constitution and the Parliament and the Supreme Court works, that would have gone a long way.
Yes, sir.
But
We'll
all in
take
all,
care of that. Thank you for your suggestions. I'll
for
call
the
my co-consister. She's there.
same thing with her as well. In fact, the same thing with all four of you. The respondents, the oratory was good. You did some screen sharing as well. That was also a good approach. But one major problem, you conceded on the arguments. You were actually relying upon committee reports which are in the favor of the petitioner. You argued that you conceded that the law was in fact, being misused and abused, and therefore it requires changes. So that concession on your part is a major problem. You should not be doing that, if you go further in the semis or the finals. So that's a major problem. You stick to the ground, you stick to your argument, because, ultimately it's a moot court proposition and it's been drafted in a manner that both the parties have certain points to argue. Okay, but as soon as you concede that, okay, yes, there are problems with the law and it requires amendment, it loses the entire purpose. It's a moot. You have to stick to your ground and you have to justify your position that why it is not unconstitutional. Okay, and again, the grounds are only that because it is not violative of the basic structure. Again, when you have, your issue number 3 as basic structure, but when we asked you what basic structure was, you fumbled. You took your time to find out what the basic structure was. So you need to do more reading on the basics, at least on the points which you have stated in your memo. Okay. So yeah, otherwise, oratory wise, court manners, everything was good. Just work on the law, the basic understanding of the law. Of course, we don't expect you to know everything, but at least the basics should be clear. Okay, when you're citing judgments, you need to know which court and what citation. These are the basic things that you need to be aware of. So you need to work on that. So that's from my end. Manav, is Manav logged out? Courtmaster, can you ask Manav if he'll be logging in or should we?
His
Yes.
Manav, you have something to add?
Yes, I would like to speak to Vibha Patel. Is she here? Yes. So, I think you should really brush up your skills on jurisdiction, because whenever you come to a court, any court, you should find out how this court has jurisdiction. That's the first thing that you'll have, because even if you file it, they're going to dismiss it or return it or not number your case on the point of jurisdiction. One thing that you have done, which you should never do, is read your entire arguments. You prepared one and you never tell the judge you prepared a speech. You are not in a, what do you say, in a seminar where you're giving a speech. You're arguing for your client. Never say you have prepared a speech, okay? And never try to understand one thing. You reading your entire arguments that you prepared is not your intention. You winning your case for your client is one, or you trying to win for the case for your client is one. The second thing is how much you are impressing and trying to convince the court. That is the only thing that has to be looked into. Even if you read 2 lines of your preparation and the judge is convinced, you should stop. But you were concerned with, I prepared 10 pages, I want to read the entire 10 pages. So that is something very bad. We were trying to engage into a conversation with you, but you were not wanting to engage into a conversation. You were wanting to finish that book that you prepared. So don't do that. Okay, that is another suggestion. You have used your case laws in a good manner. I like the way you used your case laws. And I think you should always, when you're coming in a constitutional challenge, you should give better examples whether you know the clear facts. And this is my feedback for you. Krishna Parihar. Yes, she's here.
Yes.
Again, you were the one, you also read your entire. This is, I think the team had prepared in one fashion, I think. So do not read your entire pleading. Carry barracks, as my friend also told. You cannot be confused. You cannot come to court. Actually, many a times, even we have heard this from the court. We never expect sometimes the judge is going to ask about some other law. So we might just go and he'll be like, What does this act say?" Luckily, we use the phone immediately. You will not even able to use your devices quickly to pull up the schedule 10. Schedule 10 में क्या लिखा है अभी नहीं पता था is very poor. That is something you all are challenging schedule 10. What is schedule 10? Which clause, which paragraph? Let me look into the provision. No, that is not how it is. Where is merger? Where is disqualification? It has to be on the tip of your fingers. That means you have not read the 10th schedule at least 10 times.
Yes.
You would have read your 10th schedule at least 10 times. I'm sure you would have known disqualification is 6, merger is 4, voting is 2, right? So this is something that you have to keep in mind. Okay, but you had despite us driving you to the edge of the cliff, you did not fall off. You answered questions with confidence. That is something that I liked in the entire round. All four of you all, despite us being we were comparatively very sweet, I must say. I have come across I have been in my previous rounds I have been worse than today, but I have come across people who have been not even let us argue in the court of law. So, having faced such things, you have seen a very mild bench, I must say. And a bench which speaks is a bench that it is silent. Suppose if a bench is silent, you will think, oh, bahut suna hai. They are going to pass orders in my favor. Then you will be shocked it is a dismissal. Then you will think, Arey, at least if the judge would have told me his thought, I would have tried to convince him or her, right? So this is something that you all. So good confidence while answering. Coming to respondent, speaker one, Kanisha K.
Yes, sir.
Kanisha or Kanishka?
Kanisha, sir.
Kanisha. Okay. So Kanisha, you had a very well structured argument. I was very happy with your argument. How you opened. You had a good breakup of issues. You had good answers on maintainability. Maintainability point you had answered very well. And you were very patient. You waited for my question to finish, you waited for my brother's question to finish, and then only you gave an answer. So you had good confidence and you had a good knowledge of law. The only thing you didn't do well was you conceded. When you are going to argue a case, you have to till the end not agree. You cannot say, "Ha, theek hai, I agree, we can just get it partially, it can be modified." No, you should, even if we say that you are wrong, you should say, "I beg to differ with your lordships," and give us a reasoning. Okay,
Yes, sir.
that is something that you should do. Only for that one thing, I think I would have deducted 1 or 2 marks here. Otherwise, I was really happy with the way you have argued. Okay, so good job.
Thank you so much.
So, Sukrita CA. Okay.
Lordship.
Hello, Sukrita. Uh, you are arguing on basic structure. You're not aware what is basic structure. That is not how we should go. Okay. If you,
Sorry.
yes. So, when you're arguing something so heavy, at least Google on what does it mean peripherally. As soon as we threw the question of everyone talks of basic structure, Everyone tells Keshavananda Bharati and they talk of basic structure. You ask what is basic structure? They're like, okay, what is it? Then we asked you whether the principles of equity would apply. It might not apply. Okay, it does not apply. No, you got it next.
I know, Your Lordship. I fumbled a little bit. I'm sorry,
Yes.
Your Lordship.
We're just giving you, these are all experiences. See, you come from the prelims of 71 teams you have reached. Only 8 teams have come to quarters. So this itself is a very big win. So you don't think of it is, I fumbled, it is all a win. Okay. All these are stepping stones to success. Okay. So don't take anything. Our advice is so that you can do better. Okay. And next thing was that document. That document was you shouldn't have share screen. If we as moot committee would not permit sharing screen, you would have been saved, I'm telling you. You shared the screen and you hit your own leg. That clearly said we are okay with these things. And then it spoke about the speaker. See, that's why judges always tell, some judges tell, do not highlight the case, give us the entire judgment because we get prejudiced if you highlight. You highlighted that one point. I was very curious to see point two. And then that again went against. So be very careful. Okay. Uh, Even when you're reading, you try to maintain eye contact. See, I am not telling that you people have to come to court by hearting your entire arguments. No, we have documents running into 4,000, 5,000 pages. Impossible for us to read it. So we just read it, but we know what the crux of the matter is, right? So try to do that. Read on facts and the law, because you again made a mistake on legislature party, and it is not political party in that clause. They especially said 2/3 of legislature party, clause 4, merger. So that consent point, that's why I specifically asked, is it legislature party? So we were giving a hint to you that you might be wrong. Okay, so you should be a little more careful otherwise, right? One suggestion to this team from the respondents, please see to it that you all do not sit in your school where there's so much interruption. Virtual round hai, you could have sat in your homes more conveniently, taken one day Dumma or holiday from your college, and had a peaceful day, I think, rather than the tension that you all had with the noise there, right? Other than that, I
Sorry,
think,
Your Lordship. That was just an interruption from the outside party. We are in a secluded space, actually.
okay,
Uh,
okay,
I will see to it, Your Lordship. Thank you.
no issues, no issues. So I wishing all the participants all the best for their future rounds. Rishabh, I would like to thank from the OC for joining us and giving us your precious time on a Saturday. And we hope to have you in the future rounds, also future editions of our moot court. Rishabh, you can send the score sheet by mail.
I'll email it to you.
Okay, right. Thank you so much.
Thank you.
Thank you so much, sir.
Thank you so much.
Thank you so much.
Thank you, Your Lordship.
Thank you, court master. You have done a good job.
Thank you. I wish the teams all the best.
Thank you.